My name's Ison Harrison and I'm a solicitor and a partner at Ison Harrison Solicitors. I specialise in complex criminal cases, money laundering, fraud and regulatory law. So fraud by false representation is a criminal offence and it's committed where a person makes a false statement or a false representation which they know is false and which they make in order to either gain financially or obtain something for themselves, or expose or subject somebody else or a financial institution, for example, to a loss. In law, a conspiracy is really quite simple. In the criminal law, it's an agreement between two or more people to carry out an act which, if it was carried out, would constitute a criminal offence. The type of sentence that a person would get for money laundering really depends upon the nature of the involvement in money laundering and the amount that's being laundered. So a person who plays a very minor or peripheral role in laundering a small amount of money by perhaps accepting the payment of a cheque which they know or suspect is from criminal conduct into their bank account for say £150, that person may well escape without a prison sentence. Clearly, as the involvement in crime or the connection to serious crime becomes closer and the amounts become greater, the chances of a prison sentence increase, and in all serious cases of money laundering, a prison sentence is almost inevitable. Sentences for fraud again vary from non-custodial sentences right up to sentences of prison for a significant length of time, and it depends again upon the amounts involved and the role that that person plays in the fraud. Confiscation proceedings are court proceedings that take place in the Crown Court at the end of a criminal case where there's been a conviction for an offence that has either generated or has been set up or intended to generate financial gain for the persons who've committed the offence. And the aim of confiscation proceedings is to strip those criminals of their ill-gotten gains. The amount that has to be repaid by the defendant in confiscation cases is calculated really by carrying out two calculations. The first is the amount that the person has benefited from by their involvement in crime. So that could be really quite simple. It could be theft of £1,000 from an employer, and the benefit figure then would be £1,000. The second part of the calculation is the realisable amount, so that's what the person's got available. If they've got £10,000 in their bank account, for example, they would have £10,000 available. Theft of £1,000 would mean that they pay back the lower of those two amounts, so they pay back £1,000. At the end of a confiscation case, when an order's been made, the defendant can be given up to 3 months to pay. That period can be extended by the defendant on application by an extra 3 months, but you would have to show that you are making best efforts to pay, and there'd have to be a reasonable prospect that you would satisfy the order in full. Where a person who's subject to a confiscation order fails to pay the order, either in full or in part, then the magistrate's court will try to enforce the order, and they'll enforce it in one of two ways. They'll either appoint people to realise assets, so they may appoint a receiver, an enforcement receiver, to sell houses or vehicles or take control of bank accounts, or they will simply send the person to prison. And every confiscation order that's made has two elements. The first is an amount that needs to be paid, and the second is a sentence in default. And if the amount isn't paid, then the sentence in default can, and often is, served by the defendant. There's nothing to stop a person who's subject to a confiscation order paying the order with somebody else's money, but that will only work in certain circumstances and generally only where the amount that needs to be paid is smaller or lower than the amount that the person has available to pay the order. Anybody who's interviewed under caution has the right to have a solicitor present, and almost everyone who is interviewed under caution for money laundering or fraud would have the right to have a solicitor present completely free of charge. If you would like any more information about financial crime or regulatory cases, then please contact the office on 0113 284 5000.